Hello and welcome to another episode of Law and Democracy, a podcast of the Election Law program at The Ohio State University. I am Steve Huffner, the Deputy Director of the Election Law program, and today, in addition to my election law colleagues, Ned Foley, who's the Director of our program, and Tony Goggin, who's a Senior Fellow of our Election Law program, we are delighted to have a guest with us, Rebecca Green, who is a professor at the William & Mary Law School, where she runs their election law program. And so we really appreciate you being with us today, Rebecca, and we look forward to our conversation.
So glad to be here.
Tony, we'll let you kick off the substance of our visit today.
Sure, Steve. Well, Rebecca, as Steve said, we're so excited that you're here on our program. And we thought perhaps we could begin by discussing the scholarship you're working on. In particular, could you tell us more about the article you're writing on alternative systems for election dispute resolution?
Yes, I would be so happy to. So I'm going to start off with a story ripped from the headlines to get us going. So on June 4th, the Department of Justice sent a letter to the Wisconsin Election Commission. I don't know if you guys followed this, but they explained that they were going to withdraw funding from Wisconsin elections under the Help America Vote Act because they said Wisconsin had failed to put into place an administrative complaint procedure to resolve complaints that voters might have under HAVA. And so I thought that was interesting, and I'd already started writing this paper about thinking about different ways to resolve election disputes other than court. And so I looked into it, and it turns out that a group called the Wisconsin Voters Alliance, WTA, had filed two complaints with the Wisconsin Election Commission. The first complaint alleged that the practice of sharing data with the Electronic Registration Information Center, ERIC, which is a consortium of multi-state consortium to help vet voter registration data, make sure it's accurate. The complaint was that this violated, data sharing violated Wisconsin law. And that was in 2022 that complaint was filed in the fall. And about a month later, the Wisconsin Election Commission sent a letter back to the WTA and said, so sorry, you are bringing a claim against us, and it would be a conflict of interest for us to respond. And so you can either pursue criminal charges with the DA, which of course was inapplicable in this case, as far as I know, or you can go to court. So a year passed, and the WTA filed a second complaint, this time alleging that the Wisconsin Election Commission was violating Wisconsin law because it was not checking IDs of voters who were voting overseas, absentee. And again, a couple days later, the Wisconsin Election Commission sent back a letter saying, I'm sorry, there's a conflict of interest, and you have to go to court, essentially, to resolve this claim. So in the interim, they had, in fact, gone to court and tried to sue under 1983, claiming that a HAVA right was being violated, a HAVA right of theirs was being violated, and that they had claimed to relief. And of course, I guess maybe it doesn't come as a surprise to you, but the court found that they lacked standing. And then ultimately, when they kind of tried coming in on a summary judgment motion, they were again denied relief because of a standing problem. And that's when and then, on June 4th, the final chapter of this was the DOJ letter threatening to withhold funding. So I thought that whole story was really interesting. And I thought it was interesting for a couple of reasons. First, I thought it was a very sad story because there was this concern by this group of voters about how Wisconsin was prosecuting its elections that went entirely unresponded to, in the sense that, they may have thought that there was terrible data sharing happening where Wisconsin voters' registration data was being shared illegally. They might have thought there were all these overseas voters that were voting illegally without getting their IDs checked. And so it seemed a real shame that they didn't get a prompt response, which, at least in the case of Eric, I'm not sure about the other one, but at least in the case of Eric, they would have gotten, an earful about how they were complying with the law. I'm sure on the other one too. I just I haven't looked into the details of what their complaint was. But the point is, it wasn't a good process because they were denied a remedy, an administrative remedy, and they were denied a court remedy, and the whole thing just did not work well. And so I started looking into what exactly HAVA requires in terms of an administrative dispute process, and also started poking around and looking at how other states were administering this requirement. That is, this HAVA requirement that that every state has to implement an administrative complaint procedure to allow voters to claim that there have been violations of HAVA Title III. And I don't know if I should pause here and let you guys react to this story, or if you want me to keep going, because I could keep going and tell you about another state that's doing something sort of brilliant on this front, in my opinion.
I would say let's hear about the brilliant state.
Okay. All right. So I started sort of poking around to see whether or not any states have databases of HAVA complaints that are brought through an administrative process as states are sort of implementing this requirement that they have an administrative complaint process. And it turns out that Minnesota has a pretty incredible archive of these complaints. And by pretty incredible, I mean they have one, which I haven't been able to find any other state that has one. So it's not actually that incredible because it's only a tiny slice of the complaints that are brought. But there was some cool stuff in it that I think is illustrative of how an administrative complaint procedure can be structured in a way that functions to remove pressure from courts. So in Minnesota's Office of Administrative Hearings, OAH, which you guys might remember from, there's a campaign lying case that involves the Minnesota OAH, which is slipping my mind. It's you know the one I'm talking about, where the OAH has to decide whether a guy is lying in his campaign. I teach this case and I can't. It's just the name is escaping me. But in any event,
we have one in Ohio that I teach too, and maybe that one has.
Yeah, maybe. 281 Care Commission or something like that versus Arneson, I think is what it is. Anyway, so the Office of Administrative Hearings has an archive of cases that they have heard, of complaints that they have heard and disposed of. And if you search their archive using the word election, you get 10 cases. And of those 10 cases, 8 of them are campaign finance related. So they're, someone didn't file a disclosure form or something like that. But 2 of them are Title III claims under HAVA. And so I went through those 2 claims and kind of looked at what they were alleging and was really happy with the way that those 2 cases were handled, in the sense that they both wrapped up in about 3 months, citing Minnesota law. And what I liked about this, number one, was that they resolved these claims very quickly. And number 2, I really liked the structure of how they did it. So Dan Takagi wrote an article about a private right of action under HAVA several years back, like 10 years ago. And in it, he claimed that he was arguing for a private right of action under HAVA. And in so doing, he kind of dogged the idea that there was a viable remedy through the administrative complaint procedure that HAVA requires states to implement. And he sort of worries about, for example, the lack of judicial review and the problem of having a partisan election official, resolving these administrative claims. But the Minnesota example, actually, if you're under Minnesota law, if you are complaining, if you're filing a complaint against the Secretary of State, the complaint actually goes to this administrative hearing office. And obviously that, removes some of the concern that you might have if a partisan election official were deciding the claim, at least with respect to claims against the Secretary of State. So I really liked that about it. I looked a little bit into the background of administrative law judges in Minnesota. They have 6-year terms, and they are only removed for cause. So there are some sort of they are insulated somewhat in those ways and others. And then the substance of what I really liked about the process is that if you read the administrative law judge opinions in the 2 cases in Minnesota, one of them is 12 pages and one of them is 18 pages. And they're really good. They kind of go through what the law requires, what the practice is, why it's that way. They even sort of go into a little bit of the policy choices that the legislature made, and sort of why the choice was made, and the sort of balance that had to be struck in the two instances. And so I thought that was a very nice example of an administrative process that worked quickly and had sort of this education function of helping the people who brought the claim understand why, in fact, they were wrong about the allegations that they were making. And in both of those cases, those complainants did not. It was actually the same group, but they did not. Oh no, it wasn't in Minnesota. It was the same group in Wisconsin. It was different groups in Minnesota. But in any event, those 2 plaintiffs did not, in fact, pursue litigation in court, even though under Minnesota law they were allowed to seek judicial review. So this is a very long-winded way of saying that I've become very interested in what I'm calling AEDR, which is Administrative Election Dispute Resolution, and its power to take pressure off of courts in an environment where litigation is becoming increasingly problematic in the election sphere. And I have a working title for this paper that's something like The Thickening Thicket and Another Way Out. Because I think sort of the premise of the paper, I think, starts with the idea that it's not just about whether courts should supervise the political process and the extent to which they should support, sort of police the political process. It's become a really toxic environment for courts of late. That is, the thicket is thickening. In the sense that, judicial legitimacy and independence is being increasingly threatened. People are using litigation as sort of a tool to make political points and raise money. And it's just become kind of even more fraught in a way that I think merits looking at other alternatives to resolving claims. So I'll stop there. I've been talking and talking. You can tell I go on and on, but that's kind of that's the layout.
Well, and so it sounds like what you're most interested in doing is exploring the potential here, or what ought to be or could be in terms of some alternatives. But before diving in a little more into that topic, could I just ask for a tiny bit more of what is actually being done now, and in particular, what the HAVA requirement itself is? And whether there are other states that have been threatened with loss of funding the way Wisconsin was last month, and that kind of thing.
So I don't believe there are other states that have been threatened with a loss of funding for failing to implement HAVA's administrative complaint procedure. I think Colorado received a DOJ letter as well, but it was on a different topic. It was not involving their administrative complaint process. So if you read the letter itself, it lays out sort of carefully what the federal law requires, what HAVA requires with respect to administrative dispute resolution processes. It has different, I think there are 5 or 6 different categories of things that every state must have under HAVA in terms of how its administrative dispute process should be, or complaint process should be structured. Things like notice, and there's sort of like a whole list which I can read you if you're interested. But it mandates that every state do this. And in 2004, the Election Assistance Commission pulled together a 50-state it distributed a questionnaire, and each state had to say how they were complying with all HAVA requirements, actually. But I was looking specifically at the administrative dispute resolution piece of this. And at that point in 2004, it was pretty spotty. A lot of states were responding that they had plans to implement it, and it didn't really give you a full picture, I think, of where things are now. But unfortunately, I haven't. I have a student who's doing a 50-state review right now, but I don't have much by way of kind of conclusions about how the states are doing in implementing this. What I have found just in the few states that I've poked around and looked at is a tremendous variety in scope of what's covered. So I think in Colorado, this complaint procedure under HAVA is used only for voting technology, as I understand it after speaking with some election officials there. And the Wisconsin implementing statute for this HAVA administrative complaint process actually says that you can bring a complaint under it for any violation of Minnesota election law. So much broader than what HAVA requires, because I guess I should step back. The HAVA administrative complaint process is only applies to complaints about Title III violations. So HAVA Title III violations, and I can explain what those are. So HAVA, does a lot of things. It sets up the Election Assistance Commission. It distributes money to states to buy new voting technology after Bush versus Gore. But it also does a few things, that are sort of more substantive. And so there's these Title III categories, including requiring that voting systems that are used in federal elections enable voters to verify and correct their selections before their ballot is cast, sort of notification of overvotes, like all kinds of things to do with fixing sort of the butterfly ballot fiasco in Bush versus Gore. But somebody who wanted to complain about that might, for example, say that a voting machine didn't have audio output or tactile capability. So another part of that same title has to do with accessibility for people with disabilities. A second category is all about provisional voting requirements and mandates that states post voter information at polling places. And so you could imagine somebody bringing an administrative complaint in that circumstance, saying that they didn't get a provisional ballot, or that there wasn't this information posted that's supposed to be posted. There's a third category about maintaining a centralized voter registration database and ensuring that it's updated and maintained. And then there is another section under Title III, which addresses identification requirements for first-time voters who register by mail. So there, that is supposed to be the universe of complaints for this administrative complaint process. But as I said, some preliminary poking around has led me to think that states actually are, some states are much broader in scope in terms of their administrative complaint processes, and others are more narrow. And the other piece of this that I haven't looked at that I'm excited to look at is I think a lot of what's going on is informal dispute resolution. So in Minnesota, if you file a complaint against a local election official, that complaint is sent directly to that local election official, who is then supposed to sort of work with you to resolve whatever the issue is. So in other words, you don't get to go to the administrative law judge in the Office of Administrative Hearings. So it seems like there's a lot going on here. It's going to take a little bit to figure it out and then describe it. But I don't know if I answered your question. But
yeah, no, that's good.
Well, I'm not surprised that Minnesota has a good system. Steve took the lead for us at Ohio State some years back, where we studied what we called the election ecosystems of
I remember.
Midwestern states. Wisconsin was one also, and Minnesota came out as the most good government state in terms of its political culture. So to the extent that it has a good administrative procedure, that seems in keeping with the kind of state that Minnesota wants to be in general in this regard. A little disappointing that Wisconsin was so dismissive of this. I would have guessed that Wisconsin was somewhere in the middle, as opposed to states like Ohio and Illinois, more brusque in terms of how they handle citizens.
But I also think it's not fair to pick on Wisconsin, because I am willing to bet that, the election officials in Wisconsin have worked overtime to try and sort of deflate some of these allegations. And I don't know the backstory of why they recused themselves in this matter, and there may well be a reason that isn't apparent from the surface. So I guess I just want to couch it in terms of Wisconsin being unlike Minnesota, being a swing state and having a lot of pressure on its election administrators, and maybe there's a backstory that explains some of why they push back.
So, as you're thinking about the potential here, are you inclined to want to see states develop more robust administrative dispute resolution processes for a relatively limited category of issues, the way HAVA does just for their Section 3? Or are you thinking more broadly yourself about what you'd like to see?
Yeah. When I started writing, before I got onto this whole HAVA kick, I was approaching this from a dispute resolution design angle. So people who study alternative dispute resolution, DSD is kind of the thing. Like you think very holistically about. Usually, it's about an institution, like a company or a university or something like that, and you think about mapping where the disputes are happening, and then figuring out how you can design a dispute resolution system that stops disputes from happening, but also sort of figures out where they're happening, and figures out how to resolve them quickly and efficiently, and so that the whole organization can benefit. And so I thought I was going to be sort of approaching this in this dispute resolution design mindset, which I wanted to try to sort of think holistically about sort of where are disputes happening. Are there ways to prevent them from, metastasizing into litigation? And so I think I had a very broad scope going into this project. But having started to write, it gets too big too quickly, I think. And so I'm really happy to have this kind of nice narrow slice to look at in terms of how states are implementing this HAVA requirement. But I have been surprised to see the several states that I've been poking around and looking at, how most of them have sort of a very broad, even though it's not under the Title III kind of command. Like in Virginia, for example, they have a portal where anybody can raise a complaint about anything, and it doesn't even mention Title III, at least in the instructions for members of the public. So that's something that I'm going to be really interested to look at. And I think my gut reaction to your question in terms of how broadly I think the scope of the types of disputes that an administrative dispute resolution process might handle, my gut reaction is to think, since my goal is to figure out ways to quell people's concerns before they get to the point where someone's wanting to sue in court, I would think it would make sense to have sort of a broad approach. Then again, if you have a really robust administrative process, you don't necessarily want to overwhelm it with claims, and so narrowing the scope could serve to make sure that it's functioning properly and not overwhelmed. So I guess that's the balance.
So one thing I'm interested in this is the role that DOJ is playing, and the federal government generally. In your research or in your thinking, have you thought about the extent to which there's a sort of state sovereignty, 10th Amendment type challenge to the possibility if the federal government tries to micromanage the way states do their administrative procedures? I mean, it's great if a state like Minnesota comes up with good procedures on its own, but given the policy of decentralization with respect to election administration, and the fear of what we're seeing right now is, President Trump attempting to order the EAC to adopt his interpretation of HAVA and other federal law. What do you think is the balance between state authority and federal authority for purposes of implementing, the HAVA rules, including the administrative rules?
Yeah, that's a great question. So I guess backing up, I spent a little bit of time poking around at why Congress put this administrative dispute resolution mandate in HAVA. And it's really, the record is pretty skimpy, but it seems like, Mitch McConnell is on record saying that, he wants a quick and cost-efficient way for voters to, complain. And then there's some sort of back and forth about a private right of action, and I guess Democrats wanting a private right of action and Republicans pushing back against that. And then there's also the sort of motivation of wanting to make sure that the federal government didn't take over this process. In other words, that states could take their own conditions into account when designing their administrative dispute resolution processes, and that they wanted to sort of respect the right of states over their, to run their election systems. So it seems to me like there's a good argument that that HAVA's administrative complaint mandate was born out of respect for states' sovereignty in overseeing their own election process. And I think that given the different approaches that states have taken, it does seem like they have been trying to adopt them to local conditions. And so I think just like you're getting pushback to the Trump administration's attempts through the EAC to kind of impose its vision of the world on states, I think you're going to get similar pushback when it comes to implementing this part of HAVA. But there's always this push between, do you want something that's federalized and uniform, or should states be able to control? I think that's no less true here.
And it sounds like, if I'm understanding the Wisconsin situation, the complaint is that Wisconsin offered nothing. In other words, to tell the citizens who had a complaint, you've got no administrative recourse, you can only go to court.
Right.
Does seem inconsistent with an obligation to at least provide some administrative procedure.
Right. And, I'll leave the election official nameless, but I was talking to a state election official in another state who just was like, why did they do that? They were just, it doesn't make any sense, why they would recuse. So it is, I think that's right. I think here the Trump administration, the argument the DOJ is making is that there was no remedy available because they recused.
It also seems to sort of be missing the point of administrative remedies to recuse. I mean, we have these in a lot of contexts. You think about the Administrative Procedure Act at the federal level and all the mini APAs at the state level. And this notion that when you have a grievance with a government agency, you try to work it out with the agency first. Well, every single one of those arguably could have the same conflict that the Wisconsin Election Commission was positing.
Yeah.
And yet that the notion is we should try to work it out in that less litigious way where we can and exhaust those administrative remedies where they do exist.
Yeah. Yeah. I think, the litigious culture that election administrators find themselves in, could be kind of impacting the thinking here in the sense that, you're going to go to court anyway. Why waste our time? I'm just speculating, but it does feel like, certainly the normal course is that, you're going to be forced by a court to, exhaust your administrative remedies first anyway. So, you would think that would be the expectation. So I don't really know what to say about why Wisconsin took this route. But the exhaustion of administrative remedies question is also something that I've been poking around at. And a couple of things are interesting there. One is it seems like the exceptions to the exhaustion doctrine are quite broad. And so I think what's happened, and I'm still looking for good examples of this, I've only heard about them anecdotally, is that judges can really pick and choose which cases they want to take. If they want a case and somebody hasn't exhausted their administrative remedies, they can get it through one of these kind of capacious exceptions to the exhaustion doctrine. Or if they likewise, if they don't want a case, there are ways to send it back. So I think that introduces kind of a wild card into the whole system as well.
Rebecca, you mentioned the amount of pressure on local election officials in the current political environment, the environment of the last several election cycles.
Yeah.
You wrote an fascinating article last year in the Washington Lee Law Review regarding legal support for local election officials. Can you discuss that article and sort of how it intersects with your current research?
Yeah. So I wrote this article about legal support for local election officials after a conversation with a grant funder about state funding bans for private funding bans for states, and really interesting questions about like what counts and doesn't count, and what can kind of go forward or not, and what resources local election officials have. So you may be aware that there are some private organizations that have been trying to help local election officials who get personally attacked for their work. They're receiving threats and they're being harassed, and they're being inundated with kind of FOIA requests, and the job has just become a lot harder, at least in the post-2020 environment. And so there were some organizations that were working to sort of help local election officials manage that deluge. And when the private funding bans started getting passed in states which prohibit private money going to support the work of election officials or to support election officials, depending on how the funding ban is worded, funders started sort of asking the question of like, well, what can we do and what can't we do? And so as I was having that conversation, I started to think about what legal support local election officials have, and is it adequate? And without private money, what are they left with? And so that's really why I wrote this piece. So I spent a little bit of time just in that article talking about what lawyers do to support local election officials, what kinds of needs they have, both in their official capacity and in their individual capacity. And then sort of thinking about who are the people, which lawyers are providing this support for local election officials. So it turns out in smaller jurisdictions, often it's a county attorney who doesn't have any idea, doesn't know the first thing about election law. In bigger jurisdictions, places like Philadelphia, for example, you have somebody who is hired to be the election lawyer for the city of Philadelphia. So and that's all she does all day. So there's a lot of variation in terms of the who is providing the support. But it in addition to the funding problem, so if you're getting sued a lot more than usual, then where is the money coming from to pay for your legal support? That's sort of one question. But there's also this problem of subject matter expertise, and these laws in states being convoluted and very complex. And if you're used to doing zoning law and you've got an election case, you may be in over your head, or at least not be able to provide the kind of support that the election official would need in that situation. And then the last, I think, thing that makes it really hard to get adequate legal support for election officials is political pressure. And you're operating in an environment where people may not want to represent you because of their political views. And there's been some examples of that I talked about in the paper, about how complicated it is to like which side lawyers are on politically, kind of impacting their ability to represent local election officials. So it was an interesting paper to write. It was a symposium piece for Washington Lee. It was mostly intended to get people thinking about it, as opposed to necessarily solving any problems or sort of figuring out what to do. But I think, make a few recommendations in that paper for sort of how to help election officials who are facing unprecedented levels of litigation.
Well, most of what I have been seeing about that particular issue has been focused on providing legal support for the local election officials once they are themselves defendant in a traditional lawsuit in some fashion or other.
Yeah.
But let me ask what you see as the potential here for shifting in some way, whether formally or informally, those kinds of complaints to an alternative forum, so that it's not happening in the traditional setting.
Yeah. So, so there's sort of two tracks. One is, when the harassment that the election official is experiencing is very personal. So, they're doxing them, they're, harassing them individually, defaming them, and so forth. And I think probably a court of law is the best route in those kinds of cases. But where the allegation is that they're not, doing their job correctly, or that they're not abiding by the law as they're executing their job, that's where I think there are lots of opportunities for informal dispute resolution to resolve those problems. I wrote a paper on FOIA floods in election offices, which was a real problem after the 2020 election. I think it subsided somewhat anecdotally from what I've heard. But I don't think the FOIA process is the best way to resolve concerns that people have about the election. It's creates mountains of work for election officials. The records that you get aren't, easy to understand. And it's kind of like, it's sort of like two people talking in different languages on either side of a very wide chasm. Whereas I think informal dispute resolution processes, bring people together to try and understand each other better. And so I think there's opportunities there for sort of a better approach to resolving people's concerns about elections. So I think there's a lot of promise in informal dispute resolution that's untapped, to try and really educate people who have concerns about elections in terms of how elections function and what safeguards are in place. And I suspect, and I talked with I sort of do the rounds of election officials when I start these projects to make sure that I'm, not just sitting back and not really understanding how things are working on the ground. So I spoke with one former election official who pointed out that, informal dispute resolution is happening all the time in election offices. In fact, if you think about like their day, a lot of what they're doing, particularly if they're in environments where there's a lot of pressure on their office, they're putting out a lot of fires in ways of just what I'm describing of trying to sort of explain and kind of come together and have a dialogue about what the person's concerned about. So I don't mean, I guess I don't mean to suggest that I'm suggesting anything that's not already happening. I think I'm just trying to shine a light on it a little bit and understand it a little bit more and see if there are ways that we can learn from states that are doing it well.
And pulling together all your different or many different strands of your scholarship, I know you've thought a lot about the role of adversarial, station and how that affects issues of legitimacy, transparency, and so forth.
Yeah.
You've looked at a lot of ways in which disputes over our election system affect the public confidence in that our democracy is working or not. I know you're working with the American Law Institute on thinking about procedures for elections, disputes, and so forth. And pulling those different strands together, what's your overall sense of where we are now headed into the next year's midterms? Are you feeling like, I was pleased to say you think that some of the pressure is less on FOIA than it used to be. Do you think we're better off than we were in general than a few years ago? Or are you more concerned about the capacity of our system to handle contestation? How are you feeling?
Yeah. How am I feeling? Well, I think many of us who are in this work were shaken in our boots last November. I think, I was in DC. I was participating in an International Federation of Election Systems event. And I went to a friend's house to watch the returns on election night. And I guess I was driving back from their house back to my hotel, and the streets were empty. There were literally rats running across the streets. But the way I had to go, I went by the vice president's house. And I mean, it was just barricade. I mean, there were just these high barricades up, and it was very spooky. Driving through sort of the empty streets and everything. That day they had put, like, a lot of the businesses had put boards up over their windows, and I mean, I think it was it was a really tense environment. I'm sure you guys experienced that too. But I think we all breathed a collective sigh of relief that, we didn't find ourselves in, massive litigation and huge sort of, the election administrator's prayer was answered, and, there wasn't litigation following that election. So I feel like, when you ask that question, I feel like I'm sort of still in that lull of thinking, like, we dodged a bullet, and the system worked, and the concerns that were raised were litigated and handled, and, election administrators, again, prosecuted an incredibly smooth election. So I guess I feel like that removed quite a bit of pressure that we were all feeling about whether or not the system was going to hold. So I guess I'm just sort of hopeful that that sort of added to the evidence that American elections function smoothly, even under pressure.
Rebecca, one of the issues, and you already made reference to it in discussing HAVA, but one of the issues that was exposed in the notorious 2000 election, the Bush v. Gore election, was the underfunding of election administration. How do you assess the funding of election administration, particularly at the state level here in the mid-2020s?
I mean, it is abysmal. And, for all of the headlines that we get about, concerns about how elections are run and doubts about whether their, lists are being maintained, and all of these, just incredibly divisive kind of politics around how our elections are administered. It's unbelievable to me that the federal government and states haven't, put more money into elections to make sure that they've got what they need to do the job. But that said, I do think I worry that sort of spending too much time talking about underfunded elections may further erode public confidence in election processes. And so, I worry about walking that balance when sort of talking about the abysmal underfunding of our elections. So I guess it's sort of a tricky line.
Brings me back around to the anecdote you started with too, about the DOJ letter threatening the withdrawal of federal funding to Wisconsin, and how critical is that federal funding at this point?
Yeah, I'm guessing that it's important, but that's an excellent question. I should look into how much money that is. And I actually have no sense of, I guess my understanding, you guys probably know this better than I do, but my understanding is that HAVA money ran out. That the money to buy election technology ran out. And my understanding is that HAVA does still make grants to states, and they do have congressional funding to make grants to states. But I doubt it covers much, given that there's sort of this perennial problem of federal funding being short for elections.
Yeah, I think that's right. That's kind of what I was wondering.
Yeah.
When HAVA was a new law in 2002, as you know, the Help America Vote Act, it was mainly this infusion of money.
Yeah.
To allow states to update all their equipment, but that was a kind of one-time or at least time-limited amount of federal money for that purpose.
Right. Yeah. Maybe it's a negligible amount of money, and maybe the Wisconsin Election Commission is sort of taking it in that light. I don't know. But it was more of a fun jumping off piece for my idea.
Sure. Yeah. And it makes me want to dig in a little bit more to parts of HAVA I haven't seen in a while and see just not only what the requirement is for states to have these administrative procedures, but whether the statute itself makes clear that the funding is in some way at risk if they don't do that, or whether that's an extra link or leap.
I think that that was a factor even before the Trump administration, because I've seen court cases talking about the link between funding and compliance. So I do think that has been on the radar, but yeah, I'm curious about that too.
Well, we've about run out of time for our chat today, but we will certainly look forward to your continuing exploration of what's happening on the ground right now in terms of administrative dispute processes, and your thoughts about what we might do better and take advantage of some of that.
Great. Well,
thank you so much.
This has been really fun. Thanks for having me.
Thank you, Rebecca.
We're delighted.
Yeah, absolutely. It's great to see you.
Thank you, everyone, and take care.